Hello, this is the case study of CJN versus Minneapolis Public Schools. Here's an overview of the issue as it went through the court systems, through the Individuals with Disabilities Education Act, and I'm going to go through these different parts in a little bit more detail. We'll have a few different things that we think about this case in terms of. So the first part is the IDEA framework. I think we all know that schools are mandated to create an individualized education plan or a program, which is an IEP that is specifically tailored to meet the unique needs of each disabled child, and that is stipulated in 20 USC section 1412, and additionally, the Supreme Court decision in Hedrick-Hudson District Board of Education v. Rowley requires that the IEP must enable the child to receive educational benefits. So the child has to be meeting growth, and it needs to be working for the child, basically. So the profile of the student is CJN is an 11-year-old with brain lesions and psychiatric illness, has been a special education student in Minneapolis public schools since kindergarten, and has consistently exhibited behavioral issues but has made average academic progress. CJN was initially placed in a special program for elementary needs, or SPEN, and later moved to a more structured classroom in third grade. His support included reduced homework, additional time for assignments, a token economy system to manage his behavior, and sometimes restraints had been used. So sometimes the court noted that most of the time they were for under 1 minute, but there were 6 days during the year that the child had been restrained for 5 or more minutes. Despite the supports, CJN frequently misbehaved, resulting in timeouts and physical restraints. So then what happened was a severe incident requiring police intervention led to his removal from his elementary school, which was Keewaydon Elementary School. So the IEP team, they, over the course of the year, so from August 29th, 2000 to March 2nd, 2001, had 8 total meetings about the child. The IEP team in October and November of 2000 held a meeting, and they made a plan for him so that after the holiday break, his schedule included time at another elementary school, which was Whittier Elementary, and a day treatment program for the other half of the day with the support of a paraprofessional. So he had one-on-one support. But even after that, another crisis led to CJN's transfer to a crisis center and an agreement for home instruction. However, after 1 day of home instruction, his mother enrolled him into Calvin Academy, which was a unilateral decision that she made on her own. And Calvin Academy is a private school. So then after she enrolled him outside of the agreement that she had with the district, she filed a complaint alleging a failure to provide a free and appropriate public education and sought reimbursement for the private school tuition. And independent evaluators recommended a public separate day school setting. So she's putting him in private school, and the evaluators are recommending public. The hearing officer, or HO, that reviewed the case found that FAPE was not provided due to insufficient positive interventions and ordered reimbursement for private school tuition. But then the district appealed that, and so it went to the state hearing review officer, or HRO, and that officer reversed the hearing officer's decision, emphasizing that CJN's academic progress and the efforts of the IEP team had resulted in his average academic growth. And then in the end, the district court affirmed the HRO's decision. So then we have the complaint. So then CJN challenged that decision. So we have their argument and court review. So CJN's argument is that the district court erred by not deferring to the HO, or the original hearing officer's conclusions, and challenged the additional findings of the HRO. So under IDEA for a court review, the district court reviews the administrative record, hears additional evidence, and makes a decision based on the preponderance of evidence. The courts give due weight to administrative decisions, but independently determine if FAPE was provided. And they listened to, in this particular case, there were just differing opinions. So each hearing officer, so the hearing officer and the hearing review officer, both used the same factual evidence, but they came to different opinions based on the way they interpreted the evidence. So the court found that the HRO's conclusions were based on legal interpretations rather than differing factual determinations. Both the hearing officer and the hearing review officer embedded actual facts within their conclusions of the law. And the court decided that the district court appropriately gave due weight to the HRO's conclusion and affirmed that a free and appropriate public education was provided to CJN. So then we have the challenge for the reimbursement, which is really kind of at the basis of this case, which is why Mom filed the complaint. So we have the challenge, which was CJN argued that the district court wrongly denied reimbursement for private school tuition. The court reviewed, and they reviewed the standards that were required, and the determination of FAPE is reviewed de novo, or legal conclusions, or for legal conclusions, and for clear error in factual determinations. The arguments for CJN on free and appropriate public education was that they emphasized behavioral issues, and so like the increase in the behavioral issues and the lack of positive interventions, saying that the child had not had any real issues until third grade and the change of the classroom. And they cited the lack of, I stated that. So the lack of positive interventions, arguing that Minnesota's laws requirements were not met. The district's response was that they argued that the IEPs were appropriately designed with various positive behavioral interventions and highlighted CJN's academic progress. So the district is relying on the progress of the child, saying that they're making academic progress, so the other interventions must be working. The court's observations and considerations. The court considered both academic progress and the specific efforts of the IEP team. While acknowledging additional positive interventions might have been beneficial, the court recognized the district's good faith effort, citing those 8 IEP meetings and the 2, it was specifically the 2 in the beginning of the year. Minnesota state standards, so the court clarified that procedural deficiencies did not equate to a denial of a free and appropriate public education. And in conclusion, the district court upheld its decision affirming that the district provided CJN with a FAPE and they denied reimbursement for private school tuition. So then we have a prospective placement argument. So for IDEA's preference, IDEA favors, as you know, least restrictive environment or class attendance with non-disabled peers. The Supreme Court favors public school placement, as stated in School Community of Burlington v. Department of Education of Massachusetts. So there's also an Eighth Circuit position on this. The integration is satisfied if there are both disabled and non-disabled students at the same school, as established in Mark A. v. Grantwood Area Education Agency. So the court decided that Crawford Academy, which is where the student was, included non-disabled students, so that met IDEA's requirements for integration. And then we have the stay put provision. So in this provision, CJN argued that the district court erred by not allowing him to stay at Calvin Academy during the appeal process. So while this whole thing was going on, they didn't let him stay at the private school, or at least didn't allow for reimbursement of tuition. There had been an interim agreement that covered CJN's attendance at Calvin until February 4th of 2002, and that and they are saying that did not affect the stay put placement. But the court determined that CJN's mother was responsible for tuition after February 4th. The initial hearing officer's decision said that federal regulations required treating a hearing officer's placement as an agreement. And Minnesota law differentiates local education agency roles from state education agency, with the hearing officer's decision conducted by the school district. So the review officer denied private placement, meaning no agreement to change the stay put placement existed. And in conclusion, the district court correctly held that, or the court said that the district court correctly held that there was no agreement to change CJN's stay put placement. So they're saying that he couldn't move. We did have one judge that was in dissension. So Judge Bai argued that academic progress is an important factor, but not the sole criterion for FAPE. So he's saying that even though the child is making academic progress, that can't be your only reason for saying that the child received a free and appropriate public education. And he cited case law as established in Rowley. Interdependence of academic and behavioral issues. So he's saying that behavioral issues can affect learning, and therefore progress indicates behavioral management. IDEA requirements. He said that IDEA requirements, or IEA does not require maximizing potential, but providing a reasonable opportunity for educational benefits. And then there was also case law with Neosho RV School District versus Clark. The Neosho case highlighted the inadequacy of behavioral interventions despite academic progress. So the judge is saying that even though the child is making academic progress, the behavioral interventions are still not serving the child to the best of their ability, so that the child can thrive. And just because there's academic progress being made, that does not mean that the child is receiving a free and appropriate public education. So that was the judge's dissension. So section 7, we have affirmation and dissent. So the majority of the court affirmed the district court's judgment, concluding that CJN's IEP provided educational benefit. So they're saying it was working for him. And then Judge Bai, I assuming it's a him, in Judge Bai's dissent, he argued that the district should adapt to CJN's need and not the other way around. So the student should not have to adapt to the district, but the district should adapt and tailor their approach for FAPE for the student. So there's the outline of the case. And then, so I have some questions. So evaluate the court's assessment of whether CJN received FAPE, considering both academic progress and behavioral management. What evidence from the case supports this determination? And then the second question is, discuss the district's approach to behavioral interventions, including the token economy system and one-to-one paraprofessional support. Were these interventions sufficient under the IDEA's requirements? Thank you for taking the time to listen to my presentation. I'm sorry for the small stumbles I made, and I will see you in class soon.